I think, the Latin Americans. Good afternoon for the people in Europe, and good evening to the people in Asia, I believe. It is really an honor to be here today with Eleonora. Eleonora is one, I think that it's, within the IP academics, I think that it's one of the most recognized IP academics in all the world. Not sure if you have heard about the IPCAT blog, and she's one of the leaders there. That is one of the, if you want to know some things about IP, I think that it's in the world. I think that this is one of the best blogs, and Eleonora is in charge in major part in this blog. Eleonora will talk us about today about a topic that is really interesting. It is a topic that is always mandatory for IP practitioners. I remember when I was doing my master, my LLM in IP, there was always this discussion of how to protect the three-dimensional objects, the furniture, because there are many situations between the protection of copyright, of trademarks, of designs. So these will be the main topics that Eleonora will talk us about today. She will bring us so many cases. One of the cases that she will mention is about the EAMS chair, that it's a chair that I believe that many of the people that are hearing me today have seen this chair. For example, not only in Colombia, but I have seen in many parts of the world this chair made by third parties that I'm sure that they don't have a license. So this is a big discussion of how, if it's really worthy sometimes to have this copyright, because I believe sometimes the right owners are not gonna sue the people that are producing or infringes these rights. But it's really interesting to see how this IP, the IP beside all these three-dimensional objects. Let me just read an introduction, a brief bio of Eleonora. Dr. Eleonora Rosati is a tenured associate professor in IP law at Stockholm University, a guest professor at SAPI Strasbourg University, a research associate at EDHEC Business School, and of counsel of the law firm Bird & Bird, a long-standing contributor to the IPCAT and an editor of the Journal of Intellectual Property Law and Practice, Oxford University Press. Eleonora is the author of several articles and books on IP issues, including most recently Copyright and the Court of Justice of the European Union, Oxford University Press, 2019. I read that this was awarded as the Copyright Book of the Year. I saw that this as well, so you can see that Eleonora is really known especially in this copyright topic. Now I'm gonna explain a bit of the methodology of our debate. Eleonora will talk about the topic 30 minutes, and then we will open the debate for questions or comments. I will be the moderator of the questions. If you have questions, you can write us in the chat on the right side. You can write all the questions in the chat, or you can also ask for the floor or raise your hand, and I can moderate and translate the questions to Eleonora. So, Eleonora, please welcome to IP Time.
Hello, everyone. Thank you very much for having me. It is a great pleasure and an honor to be here with you today to discuss a topic that is the IP protection of 3D objects. That is a never-green topic in IP law, as you, Jose Roberto, were indeed mentioning, but that in Europe, and that is the perspective that I will be using, has become quite topical, especially in recent times, following a string of decisions of EU courts, in particular the Court of Justice of the European Union. So what I will be doing will be to provide a perspective on these recent developments and focus in particular on the situation as far as copyright and trademark law is concerned. Of course, I will be using concepts that are proper of EU law. So if at any point anyone has questions regarding EU law, what, for instance, a directive or a regulation is, please do interrupt me and I shall try to make myself clear. I've prepared some slides just to show you the objects that I'm speaking about. So I shall be sharing my screen and I shall start my presentation. You should be seeing my slides. So let's focus on 3D objects and copyright first. As I mentioned, my perspective for the time that we have at our disposal will be on copyright and trademarks. And my objective will be indeed to see how easy it is to claim copyright protection in 3D objects, how you can play with copyright and trademarks, and what challenges are ahead for wannabe right holders as far as these two intellectual property rights are concerned. As participants will know, of course, copyrights and trademarks are not the only possible type of IP protection. There are also design rights, which in Europe are both of a registered and unregistered type, and they can be obtained on both a EU-wide and national basis. And then there might be also other types of regimes, such as patent protection, if the object in question indeed is an invention that satisfies the requirements for patent protection. So let's take a look at copyright. And here, you know, when I have my classes on copyright, I always start from the requirements for copyright protection. Every copyright student knows that for copyright to arise, there must be a work that is authored by someone and that fulfills an originality requirement. This is what we are all told during our first copyright classes. However, it will be a bit too simple to say that copyright always arises upon fulfilling these requirements only. There might be indeed other requirements that need to be satisfied and which depend on either the work at issue or the jurisdiction considered. Let me focus one moment on issues of jurisdiction. In fact, there are countries in Europe that require the work at issue to be fixed in a tangible form. This is an optional requirement under the Berne Convention. And there are also countries that require the work to belong to one of the categories. This is, for instance, the case in Europe of countries like the United Kingdom, Ireland, Cyprus, and Austria. I also mentioned that there might be additional requirements that arise because of the type of object that is attended. And that is indeed the case of designs in many jurisdictions in Europe, or at least it has been the case for a long time in certain jurisdictions, in particular in continental Europe and also the United Kingdom. Here on the slide, you see a photograph representing a couple of cheeses, and the reason why I've used this photograph is because the case that you see referred to in the slide is a case through which the Court of Justice of the European Union defined the concept of work by having to interpret this notion in relation to the taste of the spreadable cheese that you see in the slide. So, I mentioned that as far as designs are concerned, there have been traditionally countries that have required something more than just originality. And this has been the case, for instance, of Germany, it has been the case of Italy, it has been the case of Portugal, it has been the case of the United Kingdom, where the relevant category for designs has traditionally been the category of works of artistic craftsmanship, which is found in the Copyright Designs and Patents Act. This approach needs to be confronted and opposed to that has been employed, for instance, in France, where the approach has been that known as unity of the art, meaning that all objects potentially eligible for copyright protection should fulfill the same requirements. In the countries that I mentioned earlier on, that is Germany, Italy, Portugal, UK, something more than originality alone has been traditionally required. In particular, there has been a requirement of artistic or aesthetic value or merit. And the rationale for all this has been that for objects of design, the natural IP right would be design rights, not copyright. So for copyright protection to be available, there should be a particular reason for that to be so. So something more beyond originality alone. And we have seen over time in Europe, over the past decade, I would say, and more precisely since 2009, a string of decisions from the Court of Justice of the European Union, which have progressively interpreted the basic requirements for copyright protection, and in doing so, made the copyright laws of European member states more and more similar. If this is a topic of interest to participants, I'm happy to explore it in greater detail. But for the sake of the present discussion, what I would like to clarify is just the following, that in Europe, there is a certain harmonization of copyright laws, but there remain still national copyright laws. So we don't have something like a EU-wide copyright title. Each country in the EU has its own copyright law, and there are certain aspects of these copyright laws that have been progressively harmonized through instruments adopted by the European Union, in particular copyright directives. And as far as the basic requirements for copyright protection are concerned, the harmonization has been quite surprisingly not that extensive, at least on a formal level. It has been through the case law of the Court of Justice of the European Union that this substantial harmonization has actually occurred. The Court of Justice has indeed acted a bit like a legislator, pushing the boundaries of harmonization well beyond the text of relevant directives. So the Court of Justice, and not legislation, has defined what originality means, has defined what a work is, and more recently, and for the sake of what concerns here, it has also defined at what conditions designs should be protected by copyright. What happened in these recent years is the following. The Court of Justice has issued a number of decisions saying that member states of the EU do not have general freedom to determine the conditions at which copyright protection does arise. There should be a uniform approach which is the same across the EU. So at some point in Portugal, there was a litigation between a producer of fashion garments and a competitor which had allegedly copied these garments. According to G-Star, which was the claimant in this case, the defendant had infringed copyright in its designs. It was a case about designs of t-shirts and jeans. And the defendant argued that there was no copyright infringement because the relevant requirements for copyright protection of designs under Portuguese law had not been satisfied. So this litigation, which really revolved around the question of when copyright protection does arise in designs, reached eventually the Portuguese Supreme Court, which in light of this preceding case law of the CJU was not sure regarding the correct answer to give in a case like that. So it made a referral to the Court of Justice of the European Union asking for guidance as regards the correct interpretation of EU law, and in particular the question when copyright protection arises in designs. I mentioned earlier on that Portugal has been traditionally a country where designs have been protected subject to fulfilling an extra requirement beyond originality. So what is interesting about this case when it was referred is that the Advocate General who advises the EU Court, in his opinion, started by noting that the question of how you protect works of applied art is probably as old as IP itself. And it is a question that over time has received different and contrasting answers. The resulting judgment of the CJU to EU observers was not too surprising. And the reason for that is that it is a judgment that is compatible and indeed compliant with the case law that it has been unfolding over the past 10 years or so. And the CJU indeed confirmed that the approach to be adopted is one in which you only look at two things. The first one, whether you have a work, and the second, whether that work is sufficiently original. That's it, nothing else can be required. So this means that the approach traditionally taken in countries like Portugal, Germany, Italy will not be correct, nor will be the approach taken in countries like the UK, where you need to identify what type of work we are speaking of before determining whether it is protectable. So in light of this COFEMEL decision, it became apparent that you cannot require anything further than just originality and a work. So at this point, this decision was issued last September, so it has been a little over 1 year, and some commentators started saying, but so if it becomes so easy to have copyright protection in designs, the other IP rights will cease having any role. Design rights become irrelevant, they're already no more limited in duration. If you are looking for a registered design, you need to apply and register it. Why bother when you can claim copyright? So this was a certain commentary that was provided in the aftermath of this decision. However, if we look at the national applications of this COFEMEL case, which have occurred in Europe over the past few months, we see that this reading of the decision might not be that correct after all. And here I shall show you some national applications of COFEMEL. The first country to apply it was the United Kingdom. The UK, as you know, has now left the European Union, but there is still a transitional period which will end on the 31st of December. And until then, UK courts are bound to comply with EU legislation and the case law of the Court of Justice of the European Union. This case, which was decided by a small claims track court, that is the Intellectual Property Enterprise Court, concerned the copyright protection of a particular type of fabric. And here, if you followed the traditional UK approach, you will need to determine if the fabric at issue is a work of artistic craftsmanship. And this is a category that requires an aesthetic appeal on the side of the work for it to be protected. What is interesting about the decision is that the judge noted very clearly that if we were to follow COFEMEL, then you cannot request any aesthetic appeal. The only thing you can request is a work that is original. So this case has been seen by UK commentators as indeed questioning the compatibility with EU law of this closed list of categories that exist under UK law. Similar approach found in Italy, where the Supreme Court a couple of months, 3 months ago, issued a decision which confirmed the judgments at first instance and on appeal in a case where the work at issue was the layout of a store, in particular the layout of the Kiko makeup stores, which had been allegedly infringed by a competitor's store layout. And here the Italian Supreme Court said that you cannot request a fulfillment of a requirement of aesthetic or artistic merit or value. In light of this EU decision, you can only request originality of the layout. There are no particular preclusions for this type of work to be protected under copyright. What is interesting, I think, of all this string of cases is this Danish decision, which was rendered during the summer. And here the work at issue is the rubber boots that you see represented on the slide. Rubber boots that do not have anything particular, if not the particular color and position of the laces and this fabric detail at the back of the boot. Here, the Danish Supreme Court had to apply the Cofemel decision and so determine whether these objects could be protected by copyright. The conclusion was in the negative, and the reason for that was that these boots did not display the sufficient originality for copyright protection to arise. So this is a decision that shows that yes, now originality might be the only requirement, but still it is a requirement which needs to be fulfilled. And it is not said that everything will be regarded as sufficiently original. Then we had this decision from the Hague Court of Appeal in the Netherlands, which José Roberto referred to before, in which the object was these IMS chairs that indeed are very popular. In some cases, they've been produced with a license from the right holder, in other cases, not necessarily perhaps. And here the Dutch court confirmed that these chairs will be protected by copyright because they would satisfy the originality requirement under Cofemel. So we see a string of decisions that suggest that indeed you cannot require anything further than originality, but that originality is an actual requirement that needs to be passed. And a further clarification of the importance of originality comes from a decision that the CJU rendered a few months after Cofemel. It is a decision concerning copyright protection of the shape of the Brompton bicycle folding bike. I guess you have seen these bikes, they are quite popular. And this is a case that originated from a litigation in Belgium, in which indeed Brompton sued a Korean company for allegedly infringing copyright in the shape of the bicycle. The response on the side of the defendant was that there is no copyright infringement because there is no copyright in the first place. Why? Because the shape of the Brompton bicycle is exclusively technical. All the choices made by the designer are meant to fulfill a technical function, that is to allow the bike to fold and be transportable. So at this point, the Belgian court, which had to decide this case, was uncertain regarding the correct interpretation of EU law provisions. And so it made a referral to the Court of Justice asking whether technical shapes, like the Brompton bicycle one, could be protected by copyright. And if so, what criteria a national court needs to take into account to determine indeed copyright subsistence. And the response of the Court of Justice was not too surprising because the court said that of course technical shapes are potentially eligible for copyright protection, but the type of assessment that you need to undertake is one in which you identify the features of the shape that are truly original and separate them from the features that instead have been dictated by technical considerations, rules, and constraints. The latter do not qualify for copyright protection because they are not original choices, while the former may qualify for copyright protection if indeed they are the result of free and creative choices on the side of the author and the personality of the author is visible in the creative result. So, in so doing, the CJU confirmed that you need to identify the features of the shape that are truly original because it is only in those features that there can be copyright, not in other types of choices. The Court of Justice also reacted to the suggested criteria from the National Court and reviewed them one by one. It said that the fact there are other possible shapes on the market to achieve the same technical result is something that, depending on the circumstances, you can take into account, but it is not decisive. What intention the alleged infringer sought to pursue is something not to be taken into account. And that is, I think, a welcome clarification on the side of the court. Then the referring court had asked, what about the effectiveness of the shape in achieving that result? And what about the fact that the shape had been previously protected by another IP right? It can be a patent, it can be a design right. And here the Court of Justice said, this is something that might be taken into account, if nothing else, to determine why the author made certain choices, because it is clear that if you obtained a patent, those choices were made to indeed achieve a particular result. So this might be taken into account. So after all these decisions, it is apparent that copyright has some points of attraction as far as works of applied art are concerned. But in my opinion, it is not necessarily said that now all at a sudden it becomes an easy right to obtain. It is premised on a requirement of originality, and indeed this requirement needs to be fulfilled. As the Danish court decision shows, this might not be necessarily something that each and every object is capable of doing. And secondly, and perhaps even more importantly, you need really to differentiate and separate choices that are purely free and creative and which confer originality from choices that are technical and therefore insufficient to qualify as original. If your design fulfills an originality requirement, it is clear that copyright has many points of attractiveness. It does not require any formality, it arises automatically, in fact. It has a broad scope and a long duration. So it might indeed overcome the need to think about obtaining registered design rights and also enforcing design rights. It might become indeed something very powerful in the hands of designers. And also the standard of infringement has been qualified by the case law of the Court of Justice, and there is a prima facie infringement of copyright when what has been taken is original. So indeed, if the defendant has incorporated the choices that are truly free and creative and made your design eligible for protection in the first place, then there is an infringement. Another point of interest is that thanks to this case law of the CJU, there is greater uniformity across Europe. And according to some, this means that it will become easier to enforce copyrights across borders because the requirements for protection are the same. Copyright is something that in the aftermath of these decisions is worth also considering in light of the difficulties that exist under other IP rights. I told you that I would mention briefly the case of trademarks because I think that it is quite telling to see what happens as far as trademarks and objects of applied art are concerned. It is quite difficult to obtain a trademark registration for these objects in Europe. And there are two main obstacles along the way. The first one, and the most probably relevant from a statistical standpoint, is the difficulty in satisfying the distinctive character requirement. Formally speaking, there are no differences between different types of signs. There is the same standard of distinctive character under European law. However, as a matter of practice, offices like the EU Intellectual Property Office are quite reluctant in accepting applications to register, as you see, patterns, shapes, because they move from the assumption that consumers are not in a habit of considering patterns, shapes as indicators of commercial origin. So indeed, you need to have something that really departs significantly from the norm or custom of a sector for that something to be considered distinctive. So here you have three examples. The first one is, I guess, something that is quite recognizable. It is the pattern that you find on the sole of Birkenstock shoes and sandals. And according to the Court of Justice of the European Union, the refusal to register this pattern was correct on the side of the office. And indeed, the consumers will see this pattern more like an ornament, a decoration, rather than an indicator of commercial origin. Also, Louis Vuitton, despite the iconic character of some of its patterns, has struggled obtaining trademark registration for its pattern marks. The most recent case is the one that concerns the Damier Azur pattern, in which the General Court opened quite timidly the door to registration, but for the time being, there is no EU trademark as yet for this particular pattern. Final case, the Moon boot. It is an after-ski boot, which was denied registration because indeed the shape of the boot was found to be insufficiently distinctive. So distinctiveness is a big and first problem, but it is not the only one. In Europe, in fact, there are also other absolute grounds for refusal or invalidity, which relate to shape or other characteristics. And as you may know, shapes that are exclusively technical shall be refused trademark registration. However, what I would like to mention here is the fact that in Europe, registration shall be also refused for signs that consist exclusively of the shape or another characteristic that gives a substantial value to the goods. This is an absolute ground that derives from the old Benelux trademark law and whose presence in the EU trademark system has been criticized for a long time for a number of reasons. Probably the most significant one is because no one understood what this ground actually meant and how it should be applied. Substantial value for a long time has been considered as something having to do with the attractiveness of the shape. The fact that this attractiveness is why consumers purchase a certain object. It has also been unclear according to whom this attractiveness should be judged. It is in the eye of the examiners, it is in the eye of the consumers. What is the benchmark to be used? But now it is also becoming increasingly clear that substantial value is not only about attractiveness, it can be also about other things. And this is something that the Court of Justice hinted at in a recent decision, one that was rendered last February, in a case concerning trademark registration of the gumbots. What is that? The gumbots, you see it represented on this slide, is a 3D object that represents the demonstration of a mathematical principle. It is a shape which has two points of equilibrium, one stable and one unstable. And in nature, it is something that you see, for instance, in some turtles, which it is a shape that allows these turtles to go back on their feet if they happen to end up with their feet in the air. This particular principle was hypothesized by a Russian mathematician in the 90s and was subsequently demonstrated by two Hungarian mathematicians. And the gumbots is the representation of this principle. What happened here is that there was an attempt to register the shape of the gumbots as a trademark in Hungary, and registration was refused. There was an appeal to the Hungarian Supreme Court, which resulted in a referral to the Court of Justice of the European Union. One of the questions referred is what is substantial value? Can substantial value be something other than aesthetic value? And the Court of Justice said, yes, substantial value of an object is not only something that relates to the attractiveness, the aesthetic merit, it can be also about the value, the history of the object. So this part of the judgment is quite interesting for 3D objects because it shows that this ground can be potentially applied in an expansive way and can make it even more difficult to obtain trademark registrations for objects. And another problem has to do with the fact that lack of distinctiveness can be overcome through use of design. And this might be the fate eventually of the Louis Vuitton pattern mark that I showed before. But if you fall under one of these grounds for technical shapes, shapes resulting from the nature of the goods, or substantial value conferring shapes, there is nothing that you can do. The trademark will be invalidated if you have obtained in the past, or the registration shall not be granted. So it is indeed an absolute ground. This suggests that as far as the European situation is concerned, when it comes to 3D objects, works of applied art, copyright now has become quite interesting because in countries which traditionally had other requirements beyond originality, now originality is the only one. However, originality is a threshold that needs to be passed. In parallel to that, as far as trademark protection is concerned, we see a bit more reluctance on the side of offices towards granting trademark registrations for shapes and patterns. And the reason lies in the assessment of distinctiveness and what appears an increasing scope of application of grounds like the one concerning substantial value. I would like to finish this presentation with a little case note which shows that when you have something that is iconic, it is not said that you have something that is also protected by IP. I don't know if you are familiar with this company, Asten Sangar. It is a Swedish company which specializes in bedding furniture. And the bedding furniture, as you can see on the slide, is characterized by the use of this checkered white and blue pattern. Asten Sangar's bed are pretty famous. They are also providers to the Swedish royal household. But this is a company that has struggled quite significantly to obtain IP protection over this iconic pattern. There has been an attempt in the US to obtain copyright registration for the pattern. And as you know, in the US, it is common practice to register works with the Copyright Office. And these applications offer quite interesting insights into the assessment of originality. Here, the registration was refused on grounds that the pattern would be insufficiently original, so no copyright here. A better fate has not been found in Europe under trademark law because so far Asten Sangar has not had any luck to register the pattern mark as a trademark at the EU level. There have been problems with distinctiveness, but also representation of design. So let's see if these issues can be overcome. But indeed, this shows that when you have something that is iconic, don't rush to say, of course, it's protected. It might not be, and it is important to take into account the various requirements in a serious way, because indeed these types of assessments can lead to different results depending on how strictly and rigorously they are assessed. And with that, I would like to conclude and finish my presentation and also stop sharing my screen. Thank you.
Thanks a lot, Eleonora. Really, really good presentation. I am amazed about all the cases that you have mentioned with all the different judgments and decisions. I believe that a general conclusion in this topic is that there is not a single there is not uniformity in all the jurisdictions. There are variety. Even in Latin America, we have different decisions. For example, here in Colombia, at least is really different. I have known 3 cases, but in the end, the right owner, the most effective action sometimes is the unfair competition, because sometimes when you go to a judge here and argue a copyright on t-shirts or something. For example, I remember a case where we were saying that where we were quoting the Star Athletica case in the US, the one of the cheerleaders, and we were saying as well that that this was actually really similar, and they should have a copyright protection on these shirts. On well, it was a product, another shirts, not these ones. But the thing is that yeah, the point that I want to make is that the decisions are really different. But one question just to start the debate is, in your opinion, what type of, at least in clothing and in furniture, I know that the outcomes are really different, but for your perspective and your experience, which would be the most recommended way or effective? I think that copyright, we have the advantage of the term, that it's longer than, for example, a design, but or well, the three-dimensional trademark, you can renew it, and can be also really long. But from your perspective, from all these cases, all around the world, which will be your general recommendation? I know that it depends on the case, because it has many different factors to take into account. But which, from your experience, which would be the main strategy to recommend, for example, to a furniture designer or to a fashion designer?
What is perceived as the natural IP right, it will be design rights. And as I mentioned earlier on, in Europe, you can seek both registered design protection and unregistered design protection. There is, of course, the requirements that need to be satisfied, but if you have a novel design, this is a path that you can try and pursue. The issue with copyright is that you don't know if you have it until you test it. Indeed, in Europe, we don't have a practice of a widespread registration, so we don't have a prima facie indication that is a valid copyright. So until you try to enforce it, you don't know whether there is actually any right there. It is a risk that is inherent to also other IP rights, which might be invalidated when you try to enforce them. But for copyright, this uncertainty is real. And also, there are some jurisdictions, such as France, that require claimants to demonstrate where the originality of their work lies. And in the past, there have been some really odd cases in which a claimant failed to enforce their copyright because they were not able to sufficiently demonstrate how they were original. For instance, there was a case in France concerning copyright enforcement in a well-famous Jimi Hendrix photograph in which he has the cigarette in his hand, and the court at first instance denied the copyright infringement because the claimant had not demonstrated how the work would be protected in the first place. So copyright presents these issues. Then now that there are no other requirements in the picture, such as aesthetic merit or artistic value, I think that the trend we are going to see in Europe is a closer scrutiny into originality. And of course, there will be also considerations of policy on the side of courts, not to take originality so lightly and say, oh, but of course it is original. No, there should be a more careful assessment. Prior to these CJU decisions, the real problem lied in artistic value, aesthetic merit. So it was there that you had really the differentiation between something that will be protected and something that will not. Now I think that this role will be played by originality, and we will have a more stricter judgments as far as this requirement is concerned. So that is one thing. Design rights, as I said, if you are able to qualify for protection there, then you should pursue them. Actually, for many companies and individual designers, unregistered design right has worked quite well. So they enforce them and they have, certain chances of success. You can also seek a trademark registration, but you need to keep in mind that indeed it is quite challenging to obtain registration for these less conventional signs, so to say. And the biggest obstacle lies in distinctiveness, but we are also seeing increasing trends to take into account also absolute grounds that were considered a bit more exotic, if you pass me the expression, such as the substantial value one, which instead have been coming under the spotlight more frequently and with a greater scope than what one might have anticipated only a few years ago. So things are difficult and you need to have a multifaceted strategy. And of course, as you mentioned, there is the big ally of unfair competition, which, however, we should not think is something that exists everywhere. If you take the United Kingdom, unfair competition there does not exist. There is another type of legal action that is called passing off, but it requires the fulfillment of 3 specific conditions, and there are instances in which you would have had a clear-cut unfair competition case in continental Europe, but there it was found not to be passing off because you need to have goodwill, misrepresentation, and a damage. If you miss one of these requirements, there is no passing off. So parasitism alone might not be enough.
Thanks a lot for your answer. This part of the unregistered designs that you have also rights on the unregistered designs in Europe is really interesting because we don't have it here. In many Latin American countries, you have the obligation to have the right to register. And I have seen, for example, from IKEA, from Boconcept, many in Latin America, they really copy all the designs, and in the end, you can have protection on fair competition, but not on registered designs. We have one question from Aldo Fabricio from Paraguay. Then we have a comment from Beatriz, and then we have a question from Mario Cisneros from Argentina. So welcome to ask Aldo Fabricio.
Well, thank you, Lenora, for your presentation. It was very interesting. I just want to mention that in my country, in Paraguay, we have several cases of design models of bottle registered that once their term of protection expired, they were filed as 3-dimensional trademark and registration were granted. So I wonder how it's possible that the trademark system allows protecting objects that had already passed into the public domain. It seems to me a way to circumvent the intellectual property system, or more like an evergreening protection. So what do you think of that?
The short answer is yes, it is a way to circumvent the expiry of an IP right. In Europe, there is no prohibition per se from pursuing this strategy. So nowhere it is prohibited that the same object can be protected by different rights at the same time or at different times. And we've seen many examples of that. However, I have to say that, of course, there is a public policy concern there that you have well outlined, and we are seeing an increasing reluctance towards accepting these sorts of behaviors. And here I can say 2 things and provide one example. The 2 things that I would like to point out is that in Europe, sorry, I was muted. Registration can be refused or invalidated on grounds of public policy. And for instance, the Oslo municipality in Norway tried to obtain a trademark registration for works of art of a Norwegian sculpture, and this registration was refused on grounds that you were trying indeed to circumvent the expiry of copyright term through trademark law, and a court in Europe, the EFTA court, ruled that indeed this would be a public policy issue. Then another point is bad faith, which is now becoming a big topic in European trademark law. It is also possible to refuse registration or invalidate a registration on the grounds that the applicant acted in bad faith. And we have had a very recent example, I don't know if you guys have seen it, concerning the Banksy flower towers trademark. I can share the image in the chat in a moment. Banksy, as you may know, is a very elusive artist. We don't know who he is. We know that he comes from Bristol, United Kingdom, but he has never disclosed his identity. He has also made statements in the past that copyright is for losers, IP is for losers, but this has not prevented him from him, or rather a company that is connected to him, to seeking trademark registration for his artworks. And only a few days ago, the cancellation division of the European Union Intellectual Property Office has invalidated one of these trademark registrations, the one for the flower thrower that indeed is a graffiti that was placed in a Jerusalem mall a few years ago, on grounds of bad faith, that you were trying to obtain a trademark registration without any genuine interest in using that as a trademark. So we are seeing, you know, an increasing scrutiny that is justified indeed by public policy rationale into trying to police how the system and the different routes under the system are being used.
Thanks a lot, Eleonora. Actually, the Bansky case, that is right now the case of the moment. In case in the future opportunity, you would like also to do another IP time for this. I think that it's a really interesting one.
Let me share, you know, in the chat the details so that everyone can see it. Done.
Okay. Oh yeah, the one. Yeah. Thanks. Actually, when we have a blog in IP Time and all the information that we have with people, including in the chat, we also put it in the blog, so you can have all the record. We have also as well a comment from Beatriz. I'm not sure, Beatriz, if you want me to read it or just.
I prefer to read because we have a little time now, but yes, read it.
Okay, Beatriz said that I think that perhaps it's not so difficult to see that copyright and trademarks can protect the same shape, but it is difficult to define the extension of rights when we are in a case of imitation or exception, or limitation or exception of copyright and trademarks law overlaps. Yes.
It's just that. I think it's not the problem, case by case.
Exactly.
And it is important indeed to keep in mind that these different rights might coexist, but they have different subsistence requirements, different scope of protection, and different infringement standards. Also, the defenses to infringement are different. So clearly, if we are going towards accepting that there might be different rights, unavoidably, I think, there will be a cross-fertilization of concepts from different rights. For instance, we often read trademark decisions in which there is a discussion of originality, or we read copyright decisions in which we see a mention of distinctiveness. Clearly, you know, we are having, you know, a pollution of different concepts, and it is important instead also for public policy reasons to keep these concepts separate and assess each one on its own right and for its own right.
Thanks. We have a question from Mario Cisneros that says, having companies, Mario is from Argentina. I met him in Munich in the MIPLC, and he's a patent engineer. He was working from Tenaris, and right now he's working with Argentinian government in research and development. But he's asking us today, having companies following more aggressive protection strategies on 3D designs through trademarks and copyrights, do you think in the future design law will become a less used as protection strategy? I think so.
I guess that if you have an iconic and you know, well-established design, of course there is the issue that design rights are quite short-lived, no? So they will not be available after a certain number of years. So as a matter of necessity, in a way, to avoid that your object that is very popular, very successful, falls completely in the public domain, you can think of pursuing trademark registration. So in a way, designs, in my view, have the potential to become less key, especially for very, you know, long-lived and successful designs, but for smaller companies, emerging designers, design rights, especially unregistered ones, have proved quite good at helping them secure protection for their own designs. Now, of course, with these possibilities under copyright law, you can also invoke copyright protection. It is a right that emerges automatically. And indeed, upon fulfilling the originality requirement, it offers you quite a good weapon, which has the potential in certain key cases to overcome and design protection and make it, a plus, but not the main thing, I would say.
Thanks. I remember that here, well, in Colombia and in other Latin American countries, there was a case with Crocs, with the the sandals, the flip-flops. Somehow, no, they are not flip-flops, but they sue a company here called Evacol, that they exactly replicate the Crocs shoe, and Evacol, I remember that they sued the design because they were saying that it was not new. So I think that in other countries this design was invalidated, but then Crocs, as Aldo Fabricio was telling, then Crocs filed the application from the three-dimensional trademark, and right now I think that they have also this other case. So it is another extra protection that I think that it's completely legal, in my opinion, because other people say that it's too much, but I believe my personal opinion in these cases, I think that it is not a case of like taking advantage of these IP rights. I think that it's fair enough, and due to all these copies, because it's really, in this case, it was really the same. I'm not sure if we have further questions or comments, or we can close it here. I'm not sure if Ed would like to.
Hi Ed, good to see you again.
It's nice to see you. Thank you for having this. Thanks to everybody for putting this together. I am truly sorry that that we're having that it's so complicated doing things these days, but I'm delighted to be able to participate in things like this from my kitchen. So.
Oh, thanks, Ed. Actually, we had a problem today with the connection because somebody entered here. Not sure if it was that's what Beatrice told me, that he got a report from Zoom saying that somebody wanted to enter in the beginning. Then we were hearing like a noise, but we could eliminate this person. But then I received some people that was where they were trying to enter, but they couldn't. Not sure what happened, if Zoom blocked the access due to this. But well, at least we have this recorded, so all your nice presentation is not deleted, and it's really complete. Really, thanks again, Eleonora, for this. And in case,
I'm also happy to share it. Perhaps I can send it in the chat if it is not too big, so at least the participants have it. So at least there are all the links there. So if people want indeed to have a copy of the presentation with the links to the decisions, they can find them in the slide.
Wow, thanks a lot. We will put this material as well in our blog, so it will really help us for the people that couldn't connect today. So thanks, Eleonora, and thanks for all the attendees as well for today. And next week we will have I don't remember which is gonna be the next speaker for next week. We have you are mute, Aldo. I think that you are mute.
Yes, it's going to be Ricardo Concha from Chile. He's going to talk about the protection. He's going to talk about plant protection. Yes.
Okay, thanks.
Plant
So
protection.
Next week, if you want to also join and learn something about plant protection as well, you're really welcome. And thanks again, Eleonora. It was really.
It's been my great pleasure and honor. So thanks so much for having me, and it has been I hope a fruitful discussion, and it's been fun to exchange views with you all. So thank you very much for having me.
Okay.
Well, thank you. Bye-bye to everybody.
Have a nice day. Bye.
Bye.
Bye, Eleonora. Bye.